I'll now recognize the distinguished chairman of the full committee, the gentleman from Michigan, Mr. Conyers, for 5 minutes.
Thank you, Mr. Chairman. I wanted to thank Mr. Fine, Mr. Jaffer, and Dr. Fisher for their very excellent explanations of the statutory and constitutional basis of why we're here today. And so, do any of you have any reason to believe that the administration can deny the committee access to executive branch opinions about the legality of the TSP program or its current revisions?
I would think not, Mr. Conyers. Let me elaborate.
Please.
There's certainly an exceptionally compelling interest in the Congress in determining whether or not perhaps a criminal violation of FISA has occurred since 9/11. And the statute makes criminal only those things that are done intentionally. It's a vital interest for this committee, therefore, to know what legal advice was being given to those with an authority to order the National Security Agency to circumvent FISA. Moreover, I think the history of executive privilege shows that it would hardly be a crippling of the executive branch to require the disclosure of this kind of communication to the Congress. It has been done regularly with regard to Supreme Court nominees or even lower court nominees, where it was thought important in examining the philosophy of a nominee, what kind of advice was given the Solicitor General or otherwise. And I can recall my own experience serving as counsel on the Iran-Contra Committee, that President Reagan had given authority for the national security advisors to give blow-by-blow accounts as to the advice concerning the sale of arms to Iran and the diversion of funds to the so-called Contras. And that testimony was forthcoming. It did nothing to cripple the executive branch. The main argument that is advanced, I think, by Mr. Bradbury or tacitly is, well, if this is disclosed in this compelling interest where you need to determine whether crime has been committed, no one will be candid in their legal opinions. History, I think, discredits that. The last thing I would say is, at least the prevailing Supreme Court opinion on this issue indirectly, U.S. versus Nixon, which says even presidential communications can be forced to be disclosed in the context of a criminal investigation conducted by a grand jury, would strongly suggest if the Congress is similarly investigating that seriousness of wrongdoing in the executive branch, that even presidential communications would be forthcoming, a fortiori legal advice within the Justice Department.
Mm-hmm. Very good. Dr. Fisher, adding to the same question, the notion that the chairman, myself, and the ranking member, Mr. Lamar Smith, we could be brief, but everybody else on the committee shouldn't be brief. I don't get it. We're all cleared for top secret. What's the difference?
No, I don't understand that. I think you operate as a committee. You have to legislate as a committee. You don't do it by chair and ranking. So everyone on the committee is cleared, and they have a need to know what it is in case they have to legislate on it.
Exactly right. Mr. Jaffer, what would you add to this discussion?
Well, first, I think all of that is exactly right, Mr. Conyers. The only thing that I want to stress is, to the extent the government is relying on the AUMF, the authorization for use of military force, as authority for its actions, I think that reliance is completely misplaced. First, as I said earlier, there's no textual basis for the argument that the AUMF was meant to authorize domestic surveillance. Second, many members of Congress have come out both sides of the aisle to say that they never meant to authorize domestic surveillance when they authorized the AUMF. And then finally, the administration has relied on Humvee, the Supreme Court's decision of Humvee, but Humvee involved the detention of enemy combatants on the battlefield. That's a completely different situation than what we're dealing with here, which is a program of surveillance inside the United States directed at U.S. citizens and U.S. residents.
Exactly. Dr. Fisher, finally.
Yeah, just to add to what Bruce Fine said about the deliberative process, Mr. Bradbury is correct that there's much going on inside the executive branch as part of the deliberative process, but you're not asking about the deliberative process. You're asking for the final legal judgment to justify a program. And as we all know, OLC regularly publishes its opinions. When there's a question after the New York Times story about the legality of it, in January 2006, OLC quickly got out their 42-page white paper. So I don't understand any reason why a legal analysis, final legal analysis, not the interim one, the final one, shouldn't be made available to Congress and the public.
Chairman Nadler and I are still waiting for a response of any kind from the Attorney General, Alberto Gonzalez, about this subject matter since May 17th. We're in our generosity of spirit, we're going to give him 2 more weeks. And then, as somebody said, it's about time process kicks in somewhere around here. Thank you, Mr. Chairman.